It's my distinct pleasure today to introduce our special guest speaker. He is Justice Phil Johnson of the Texas Supreme Court. He is going to be talking to us today about one of the most significant decisions in 2015 affecting TAPA members. Now, Justice Johnson graduated from law school from Texas Tech. Thereafter, he practiced law as a defense lawyer in Lubbock. He served on the Amarillo Court of Appeals from 1999 to 2002 as a justice. In 2002, he was promoted to the Chief Justice position in that Court of Appeals. Later in 2005, he was appointed by Governor Perry as a justice on the Texas Supreme Court and has served in that capacity since 2005. Justice Johnson is the author of one of the most important decisions to affect TAPA members this year. That decision is Ross versus St. Luke's Episcopal Hospital. The issue in Ross is, what is a healthcare liability claim when safety issues are involved? Now, under the predecessor statute, 4590I, the statute required injury to a patient. That language was eliminated in 2003, and now it only requires injury to a claimant. So for the first time, the Supreme Court is giving judges, lawyers, claimants guidance on what is a healthcare liability claim when someone other than a patient is injured and it is involved.
Well, really, they were fairly simple. Ms. Ross was a visitor at the hospital. She had actually accompanied a friend to go visit a patient in the hospital. They had visited the patient. They were coming back out, and just as they were approaching the exit doors, she slipped and fell. So she sued the hospital on the basis they had improperly taken care of the floor. Well, the trial court both had held that it was not a healthcare liability claim. They held that there was no direct relationship, and that so there did not have to be a direct relationship. And they held that they followed it basically, I think, along the line of thinking that in one of our prior cases that indicated that there did not have to be, when you were talking about a safety claim, there did not have to be a relationship between the provision of health care and the incident.
In the definition of healthcare liability claims that the legislature gave us in 2003, there are really four components: be medical care, health care, safety, or professional or administrative care. In the Ross case, your focus was solely on what?
We were focused on the safety factor, part of the healthcare liability claim definition. There are several factors that the legislature put in regard to what a healthcare liability claim could be. One of those was safety, and that's where we were focused on this case. Well, the three, we have addressed it in three particular cases that come to mind. After the amendment to the Act in 2003, I think we probably first looked at it in Omaha Healthcare versus Johnson, and then also in Harris Methodist Hospital in Fort Worth versus Ollie. And then the last one before this one, probably that I would mention, would be the Williams or Texas West Oaks Hospital versus Williams. We have had a little more struggle dealing with exactly what claims are healthcare liability claims when the safety aspect of the definition has come up. Because before that, when you're talking about what is healthcare or what is medical care, the statute is fairly specific about describing that, and there's really not much confusion about if you're being treated or if you're not being treated. So the question then as to safety is a little bit different than the other questions we've dealt with altogether almost. The first argument that the hospital made in Ross as to why it was a healthcare liability claim was that it just said that when someone's in the hospital and they slip and fall, well, that clearly has to be related to health care. And so any slip and fall or any incident inside the hospital is going to be a health care liability claim. Well, the court said there has to be a connection besides simply being in the hospital, because in this particular case, as we dealt with the facts in Ross, she was not a patient. She had gone there to visit a patient. There was no indication that there was anything insofar as the hospital's duty about keeping its floor clean that would make it different from a grocery store or anything else. So said that the standards can be the same, and so the fact that she was in the hospital did not make it related to the provision of health care. The court held in Ross that her claim was not a health care liability claim because there was no substantive or substantial connection between the standards that the hospital, she claimed the hospital violated, and her injuries. And we held that there has to be, under the definition given by the legislature. For us to determine what the legislature intended, and therefore to determine what is a safety-related claim, you always look at it, first of all, you look at the language and see what they said, because you presume they mean what they said, but you don't take bits and pieces of it out of context. You look at the language in context to try to determine what the legislature intended, because that's what we try to do, follow what they intended. When we set out 7 factors in the opinion, we specifically said they are non-exclusive factors. So we gave those as guidance because those seem to be the ones that would be more prominent in this area, but we did not say that they were exclusive.
Could you walk us through the 7 factors and give us sort of what the court really is looking for in each one of these factors?
No. I think that would be speculating too much on that, Brent. But we tried to give some guidance for how substantive there has to be. I mean, there has to be some connection, and rather than just saying, just because it happens in a hospital or a healthcare setting, it's a healthcare liability claim. And so we did the best we could to come up with some factors that we thought would help the bench, the bar, and the healthcare profession in interpreting this statute that's on the books. It's important to people, and we tried to give some guidance. You know, we said in Loasiga, another case that we wrote, where it was a patient under treatment. And there we said that if you have a question of whether a claim was a healthcare liability claim when it was in the course of treatment, that in order, once that's been established, in order to show that it is not a healthcare liability claim, we said that you have to show conclusively that it is not before you can take it out of the healthcare liability claim aspect. So I think probably that would bleed over a little into the analysis of this. I don't think that the court said that these factors have to be there. I think one thing that you might look for in our opinion, kind of like legislation, if words are not in there, we probably intended for them to not be in there. So that might give a little guidance as to that. We did not specifically state in the opinion in Ross about what a trial court should or should not consider. Now, we have specifically stated that in regard to healthcare liability claim expert report, that you look within the 4 corners of the report. We did not say that insofar as these factors. So we do think that, I think a rational reading of those would be that you're not limited to the report itself. If I were a trial lawyer and representing a plaintiff in a case like this, or not a case like this, but a claim against a healthcare provider, and and I did not think it was a healthcare liability claim. Given this Ross opinion, what I would do as the trial lawyer is I would bring all the evidence I could and give it to the trial judge, and then let the trial judge make the decision. And what I would not want to do is have some evidence that I did not at least offer to the trial judge in representing my client.
Justice Johnson, we appreciate your being here today. We appreciate your service on the court and striving to uphold the legislative intent of House Bill 4, and want to thank you.
You're welcome.